Okay, we're live.
You're live. Welcome all. My name is Aaron Hall. I'm here with Rylan Warner and Luke Neerman for this week's update on immigration issues from Joseph and Hall. Thanks for joining us and thanks for watching. As always, we're going to start with some quick updates from each of the three of us, and then we will go in and answer questions in the comments if you have them. And so that said, let's just get to it. Rylan, do you want to get us started?
Sure. So this week, I'm kind of talking about just a general thing. I like to come on here and complain, but also I just want to give some shout outs this week. So, just in general, we've seen that it's very easy to cut down on the rights afforded to immigrants, the processes afforded to immigrants, but it's so much more difficult to build them back up once they've been cut away. And the routes to lawful immigration in the U.S. Can be incredibly long and frustrating. And the process to get lawful status, for instance, for the unmarried son or daughter of a U.S. citizen from Mexico can take over 20 years to complete. So as we know, that leaves a lot of people that are in the United States without any status at all. And a lot of states in the United States are voicing their frustration with how difficult it is to properly maneuver through the federal immigration system and for people to get status. And while states themselves cannot change the federal processes for people to get status, states that on their own cannot grant individual status. A lot of states have been starting to change how they treat people without status in their communities by passing laws and passing just regular policies that affect how people without status are treated. And some people might immediately jump to be offended by that, saying, well, why should we treat these people without status any differently? And I do want to remind people that, research reviewed by the Congressional Budget Office indicates that up to 75% of people without lawful immigration status pay federal taxes, they pay state taxes, and they pay local taxes. So any benefits that might be given to them are not benefits that they haven't already paid for. In fact, many people are paying for benefits that they're not receiving any benefit for because states like Arizona, for instance, even though they might accept taxes paid by people without status, they don't allow them to receive certain healthcare services. They don't allow them to receive punitive damages in any court action. They don't allow them to get in-state tuition. And so that's kind of absurd for these people that have paid into the system, but they're not getting any benefit in return. But there are states like Illinois. Illinois got a shout out this week as being a really pro-immigrant state, and that was what inspired me to talk about this week. Illinois challenged the use of detention centers in the state and have said that they weren't going to fund them anymore, and it was challenged in court, but it was ultimately upheld by the court. Does that really help people in the long term? I'm not really sure, because it just seems like, well, then there are going to be detention centers elsewhere and they might be overcrowded as a result. But at least Illinois is not putting their taxpayer money towards these inhumane detention facilities, although they may just be shifted elsewhere. But Illinois also provides Medicaid to people without status in their state. Illinois also provides state-based financial aid to people without status. And I think that's great that people are seeing those types of benefits for the tax money that they're paying. I do want to shout out Colorado. Last year, Colorado passed one of the biggest laws in terms of public housing for people without status that this country has seen yet. People without status can get public housing in Colorado, which is amazing. People in Colorado can get access to the state healthcare system. There are laws in Colorado that actually prohibit landlords from engaging in certain housing practices that might discriminate against people that don't have status in Colorado. And also, Colorado just recently has decided to move forward with a legal defense fund for people that are subject to immigration proceedings that would not otherwise have the ability or access to counsel. And so I am proud of Colorado and what we've done, and I hope that it's a sign of better things to come while we await national reform and hope that things can get better. At least the legislation, the local legislation in Colorado is working on making things easier for people without status in our state. So let's keep it up. Let's keep moving forward. I know it's a pretty general, broad statement, but that's what I have to say this week.
It's interesting because, the states can just go in totally opposite directions. We have some states doing things like that, like you're saying, like Colorado, and I'm also proud of the efforts the state is taking. Then we have states like Texas who are suing about everything that the government tries to do that's positive towards immigrants and trying to stop it. Mm-hmm. The state of Texas, I think it was last week, sued about a new or a revived program to process some Central American minors in their countries of origin to come join family members here. And often the anti-immigrant line is, we just want them to come legally and apply to come legally, and that's what this program is, and they're suing to stop it. So
yeah,
what gives? But yeah, it's always good to hear the states that are wanting to do good things.
Yeah, and there are plenty more out there that I didn't shout out. Maybe I could do that next week when I need something else to talk about.
Yeah. Luke, what do you have today?
Yeah, so, I think we talked about this a few weeks ago, but I just wanted to review the process and the procedures for requesting an expedite on your application or petition. So USCIS, they issued some guidance, some updated guidance just a couple weeks ago on the criteria that they use to determine if a case warrants expedite, which just means to speed up the processing on your case. I think this is, particularly important that people know this process, just in light of the super long processing times. Depending on what type of application or petition you filed, you could have an application pending for a year or for 2 years with USCIS. There's just massive backlogs. So in this new guidance that USCIS published, they listed out 5 main factors that they'll consider with an expedite request. I think most requests would fit into one of these 5 categories. I'm just going to talk briefly about 3 of them here, because I think these are the ones that are most applicable to folks who are needing an expedite request. So the first one they talk about, you can request an expedite on your application or petition if you're going to suffer a severe financial loss to a company or a person. And so, in this section here, they give an example of like a job loss. So if you have an imminent job loss that's going to happen as a result of the delay in processing of your application, that might warrant an expedite request. And USCIS, in all this guidance, they're really careful to say, this might warrant an expedite request. So, in no way is it guaranteed to work. But I think, these are important pieces to know. Okay, the second one I wanted to talk about, they say expedites can happen if there's an emergency or a humanitarian reason. So they kind of give a long list of what does that mean. So they say, examples of this might include, but they're not limited to, illness, disability, extreme living conditions, death in the family, or a critical need to travel to obtain medical treatment in a limited amount of time. Also in this category, they include healthcare workers who are needing employment authorization during the pandemic. that's been going on. So if you are a healthcare worker or in any way connected kind of with the broader system, healthcare system, you may be able to get an expedite on your application. That's for work authorization specifically. And then the third example I want to talk about is in the case of clear USCIS error. So they say, if there's a clear error that USCIS made in the adjudication or processing of your application or petition, that may warrant an expedite request. There's a couple other categories that they talk about, I think, that are pretty uncommon, that may warrant an expedite request. So those are the really big ones. In terms of how you do this, USCIS, the guidance that they publish, they say that you can call their contact center. So it's just the 1-800 number, or you can chat. They have Emma that pops up when you go to the USCIS webpage. You can chat and request that. I would say, obviously, if you haven't filed your application yet, good practice would be to include a request actually in your filing, explaining why you are requesting expedited processing. But in some cases, I think something is going to come up after the application is filed. So if you apply for citizenship and then there's an illness or a death in the family or a reason you might need to travel, if something comes up after you file an application, you can follow that procedure to call the contact center. Just our past experience with a contact center, it can be frustrating. You're going to call, you're going to be on hold for a little while. Eventually, you'll talk to someone. That person will give you, practically zero information on your case. And then they'll determine, is this an urgent request? In which case you may get a call back from an immigration officer in 3 days, or it could be 30 days. They also indicate that they may just send a service request to the facility that's processing your application. So, the exact process for how they're going to consider that expedite request and the time frame for when they'll make a decision on that expedite request is still a little bit unclear. But despite all that bureaucracy, I think it's definitely worth it in cases where you really need to speed up an application or petition, and it might work.
So I have a question. Aren't there just so many cases that would fit the criteria that they put in here? Job losses, a lot of people who are looking for employment authorization, and humanitarian reasons, they list illness, extreme living conditions, death in the family, or critical need to travel to obtain medical treatment. It just seems like, for example, for travel permissions, it seems like there would be a lot of their caseload that might arguably fit in there.
I think that's a good point.
Do we see, when you get a response on this, do they explain why it qualifies or why it does not? Or what happens after you make an expedite request? What can people expect to see?
Yeah, that's a good question. I don't know if either of you have had recent experience with USCIS after this guidance has come out. I haven't. Something else I was going to mention that's connected to an answer to that question. Oftentimes we will work through a congressperson's office. So you can contact your local congressional representative. They typically will have a liaison on staff that can communicate with USCIS regarding immigration matters. So, oftentimes we'll submit an expedite request through those channels. In those cases, the responses we get are not detailed. They basically say the request has been considered and it doesn't meet the criteria. So, I'm not sure after this guidance has come out if USCIS is being more specific if they do deny?
I would imagine that no, they are not, just because looking at this guidance here, it says the expedite decision simply informs the requester whether USCIS will take the benefit request out of date order and issue a decision faster than the normal processing time. So I think that like the use of the word simply there is meaning yes, approved or no, denied. They do say that there is an appeals process available for it. I don't know how successful that ever is, but I would imagine that there's no further explanation than what we're used to.
Yeah.
Yeah, and I guess that makes a little bit of sense. You wouldn't necessarily want to devote a ton of resources to writing out reasoned decisions on these requests, because you want the resources to go towards adjudications of the actual benefit requests as much as possible. But I guess that kind of leads into what my little mini update was going to be. And that's because the reason that so many people need expedite requests is because the normal processing times are out of control. And we have that's the subject of a lot of our frustrations in our practice with clients, but also a lot of our litigation is about the agency taking too long to adjudicate a benefits request. For example, right now one of our cases is the Kang case, where we're seeking class certification about how long it takes them to issue a work permit for people who are applying for their green cards. So one of the things that they always respond with in the litigation is that there's no real entitlement to receive an immigration benefit decision within a certain amount of time. And I was just looking over some of the filings in that EAD case from the government, and what they say is basically, so long as we're processing the cases on a first in, first out basis, basically as long as we have a line, then that's all the people are entitled to, and you don't get to tell a court to try to speed us up. And the reason that this came to mind was that yesterday, the director of USCIS, her name is Urjadu, she had an engagement where she was talking about kind of the state of the immigration benefits processing. USCIS is the agency that processes immigration benefits here within the United States, and she's the director. And what struck me was one of her quotes that she put out there, and I'm going to read it for you. It says, "It doesn't matter what benefit we are talking about or what you applied for, every single applicant who seeks a benefit from USCIS is entitled to a timely decision." And that's not exactly consistent with the arguments that the agency's lawyers puts forth in court, and when they say, basically, as long as they're in line, however long the line takes, that's what's reasonable. So I thought that was a little bit interesting. I think I hope that her commitment to timely processing applications is genuine. I believe that it is, but I hope that she and the other people there are taking bold steps to reduce processing times, because as it is, it's just everything takes way too long. People are waiting for years just for a simple green card application. People are waiting for literally years sometimes for an employment authorization document that they fully qualify for, and it's extremely disruptive to people's lives, and the agency should be able to do better. So we'll see what they are able to do. In the meantime, where they aren't doing better, that's why we have to sue them. So that's kind of my little update. All right. Do we have any questions?
We do. We have one from Delani Gunawardana. And she says, "Hello, Aaron and the team. Good evening. With related to Go, if the government obtains a stay, what's next? Is there an expiration date for a stay? And if so, how long will this litigation go on?"
Delani, I feel the frustration in your question. So GO, for people who don't know, is our diversity visa lottery litigation from the year 2021 for the diversity visa lottery 2021. And what happened in GO is that we won an order from a district court in September of 2021, ordering them to finally start really processing these applications, and to basically do as many as they can by September 30th of 2021. Then we got a second order on September 30th, 2021, saying that the delay in processing these cases throughout the year meant that the judge was going to reserve some additional visas beyond the end of the fiscal year for plaintiffs in GO. And he specifically reserved 481. And he ordered that they issue these visas by the end of fiscal year 2022. That means by September 30th, 2022. Since then, since September 30th, they have not processed even one of those 481 visas. They've said in other court filings that they won't even begin to process them until at least April. And their deadline is September 30th. So they have a little bit of time, but they sure haven't gotten a head start. And what they have done now is they've finally appealed the case. They had put in a notice to appeal and then said that they needed permission from the Solicitor General's office, and they got it. And so now the appeal is going to go forward. The GO case is going to be consolidated on appeal with a number of other diversity visa cases. And what they have filed for now is a stay. A stay basically would excuse them from complying with the judge's order while the appeal is pending. Because as it stands, even though there's an appeal, they have to comply with the order unless they get a stay. So the way that it works is they ask for a stay from the same judge who made the order. And if that judge denies it, then they can ask for a stay from the DC Circuit Court of Appeals. And so that's what they've done. They've asked Judge Mehta, the judge in this case, for a stay. And the question from Delani is, what happens if they get a stay? Then they don't have to comply with the order until the appeal is resolved. There would not necessarily be an expiry date for a stay, although I think the judge could craft it however he wanted. But my expectation would be that if they get a stay, which we are going to be opposing, we're not agreeing to a stay, and I don't think that it's necessarily going to happen. But if they get it, then my expectation would be that the stay would be in place as long as the appeal was pending. The next question is, if so, how long will this litigation go on? And that just depends on how quickly the Court of Appeals reviews briefs and sets oral arguments. I would not expect a decision from a Court of Appeals until at least summer, maybe more realistic fall, or even late this year on the appeal. The next question is from Ronald DaCosta, who often tunes in and gives us questions. So hello to Ronald. Does a lawsuit really work? I'm really frustrated by the GO appeal. So are we, Ronald. It does work in that without the litigation and the GO litigation specifically, there would have been far fewer DV 2021 visas issued. There were two steps to getting more issued. The first was just the litigation itself, put some pressure on the Department of State to try to look better for the judge. And so they started processing more, I think, in response to the litigation. And then specifically after September 9th, they were ordered to adjudicate more before September 30th. And so there was a rush of adjudications there that were a direct result of the litigation. Now, all of that is cold comfort for a plaintiff who didn't get one of those visas by the end of the year and is hoping to get one of the reserved visas. And it is frustrating. Will it work? I mean, I think that our arguments are still good on appeal. Our arguments prevailed before the judge, who is very careful and I think a good judge. And I don't think that he is prone to make wild rulings or anything. I think his rulings are well supported. And so I would expect his rulings to have a good chance to survive on appeal. But if they are able to get a stay of the judge's order, then it will cause further delay for people who are hoping to benefit from the litigation. And that's certainly frustrating. It's frustrating for us. We know it's far more frustrating even for you. So that's a long way of saying, yes, I think litigation works. Yes, we're frustrated by the appeal too.
New question. Going to cover our faces for a second. From Martin Piedras. He's saying that he has a sister who's a U.S. citizen, and he lives in Mexico, and he has a visa as a tourist visa to visit the U.S. He is wondering if he applies through his sister to become a resident or green card holder in the U.S., would he have any troubles with immigration to renew his visa once it expires? He wants to make sure that he'll be able to renew the visa and keep visiting his family in the U.S. during the process. And he thanks us in advance. Luke, do you have any answers to this one?
Yeah, that's a good question. We hear that pretty frequently from people. So a couple things. I mean, in general, the process to apply for residency through a sibling, if you're outside the country, it's a two-step process. The first one is you file a petition, and then once that's approved, then you have this waiting period until a visa is available, and then you go through the process to apply for a visa. So if you're from Mexico, that category of a sibling of a U.S. citizen, you can file a petition, but then the waiting time, off the top of your head, Ryland, I think it's like...
I'm looking it up right now.
I mean, it's a super long waiting time. And so, you're going to start that process. And right now, our estimated waiting time is like 15 to 20 years.
Yeah, right now, I just looked it up, and the visas are dated back to 1999 for the sibling of a U.S. citizen.
It's nuts. So, I mean, it's possible that'll change at some point in the future. Doesn't necessarily mean it's going to be 20 years, but that's how it is right now. So, when you apply for a tourist visa, one of the main things is showing that you're going to go back to your country. I think the fact that you have a petition pending for you, the consular officer may see that and have access to that when they review your file, and they may know there's a petition pending for you. So that may be, a question that they have. I don't think it's going to be fatal to your application for a tourist visa. It may mean that you just need to be ready with a little bit more evidence to show that you intend to return to your country, that you don't have non-immigrant intent. I think given the fact that the waiting time is so long, hopefully the consular officer would keep that in mind and know that there's not any quick avenue for you to get your residency right away in the U.S. if you come. So, I think it's a factor they'll consider, but not fatal, but maybe just be prepared with more evidence to show your ties in your home country.
Yeah, and I think, too, if you have a history of visiting family in the United States already, visiting and then returning and then visiting again, if you have years of trips to the U.S. where you have abided by the admission date of your visa and you've always returned to Mexico on time, they'll take that into account as well when reviewing your case to see whether or not they believe you're going to actually leave the U.S. when you're supposed to. So that's some more evidence that would go in your favor.
Yeah, I agree. And I'd just point out that obviously, Martin, we don't know much about your case or your history or anything like that, and we can't really provide specific advice. But as far as advice on whether a Category 4 petition, that's the sibling petition, disqualifies somebody from a visitor's visa or affects the visitor's visa application, what Ryland and Lucas said is right. And I just wanted to add bad news onto maybe more bad news as far as the processing time. So, Ryland points out that they are processing immigrant visas or permanent residency for people in that category from Mexico, the category of siblings of U.S. citizens from before April of 1999. So if you do that math, we're looking at 23 years-ish. But those dates, kind of like Luke was alluding to, they don't move equal to the calendar. So it doesn't mean that next month it'll be May of 1999 on the visa bulletin. In fact, there's really bad news because in 2001, there was a sunset of a law called 245I, which gave a lot of people a lot of incentive to file a lot of these petitions. So there's probably a real big glut of petitions between 1999 and 2001. And there's still only so many that can become permanent residents based on those petitions. So my expectation would be that until that date gets beyond May of 2001, it's probably going to move extremely slowly in the coming years. You know, we're probably talking about many, many decades, unless, like Luke says, something changes. And that change would likely be like some kind of new law that's aimed at clearing the backlog or giving more visas in these categories because it's so insane, the backlog. So that could be, and then there could be a benefit to having that petition by a sibling. But just set your expectations that if there's no change in the law, it's going to be, I don't even want to guess. I mean, my best guess would be like 30, 40, 50 years until you can get your residency based on a petition by a sibling from Mexico.
Yeah, and why don't people just do it the legal way? Why don't they just wait 50 years to be able to enter the U.S.? Oh, they passed away while it was processing. Oh, well.
Right.
At least they were doing it the right way. So it's so frustrating. But well, on that note,
well, we started with good news with your update on the positive state efforts. So there was some good news here.
Go Colorado.
I think that's the end of it for today. Thanks all for joining us. We'll be back next week, and until then, take care, and we'll talk to you later.
Bye, everybody.
Bye.